Hey, everybody, and welcome to Thursday Night Live, here once again, another week. Time flies when we're doing live streaming. I'm John Skiba, and I'm an attorney in the state of Arizona, and I help people with bankruptcy, defending debt collection lawsuits, debt settlement, garnishments, and all those horrible things. So each and every Thursday night, we do this where you can come in and you can post questions in the chat section over there on YouTube or on Facebook. We're also live streaming on Facebook. Put some questions in there and we'll discuss them. My disclaimer every week is that even though I am a licensed attorney in the state of Arizona, I am not licensed anywhere else. And so I can't provide you any legal advice. This is just information. I highly recommend you contact an attorney in your state who knows your specific state laws and rules and all those types of things. And this, watching this doesn't create any type of attorney-client relationship. So with all of that out of the way, again, the way that we do this is there in the chat feature. If you have questions that you want to post, you can do that, and we'll go ahead and give it our best shot. So, we have supporters of the YouTube channel. I didn't even know you could do this on YouTube until I started doing live streams, but people can donate and support the channel and help cover some of the costs that are associated with doing live streams and putting out new videos. And Dave Lamb is one of our biggest supporters, and I sincerely appreciate that. All right, let's see. I had a couple of questions. I've been doing this where I go back to the comments in the just on my channel that I don't get to. So I thought I'd start off with one of those, and this was a good one. Okay, this person said that they had their court hearing today. There was a motion for summary judgment filed. And so for those of you who may be dealing with debt collection lawsuits, this is a favorite tactic of the debt collectors, is they submit a motion for summary judgment, which is basically a written form of them saying, hey, judge, we don't need trial. We don't need, to go through all that. Just look at our documents and tell us if we win. This trips up most people, because it's different than responding to the complaint. It's not just admitting or denying. You have to go through and substantively deal with all of the different issues and documents. I have a course. I forgot I didn't plug my stuff. In the chat there, pinned at the top, I have a link to all my online tutorials that really do a deep dive. We spend 5 to 30 minutes each week doing this kind of stuff. My tutorials, it shouldn't scare you off, but some of them are several hours where we go through this stuff. There's templates. Because particularly like responding to summary judgment is not easy. And they know that, and they know they can trip you up on it. So in this situation, the plaintiff, the debt collector, filed a motion for summary judgment. The defendant responded to it here, and he's saying there was a hearing, which is normal. A lot of times courts will set oral argument if they want to talk about it. And it says here that at the hearing, the plaintiff told the judge that they're withdrawing their motion for summary judgment. The judge looked at me and said I could go home, which I like. Whatever that court is, court's different than you think it is. It's not like on TV. But and so the person says here, does this mean I won? Well, you won the battle, but the war isn't over yet. Because summary judgment, the best outcome for you with summary judgment can be either for the court to deny their motion for summary judgment, or for something like this, where the plaintiff just withdraws it because there's problems there. All that does is it puts it back on its way towards a trial. So the best case scenario is that they don't win, not that you actually win this. And so if you defeat summary judgment or they withdraw it, the case is not over. The other side may move to dismiss after something like this. This is pretty catastrophic for a debt collection attorney, where they're having to actually withdraw their motion. But it's unlikely that that we're at this point. The court's just going to give you a trial date, and you're going to start moving towards there. All right, let's. We've got to do a shout out to Marcos as well, who's one of the biggest supporters of the Consumer Warrior YouTube channel. All right, let's see your question. The judge didn't rule on your motion to reconsider, just ruled in favor of PRA summary judgment. Do I have any options? Will they start garnishment? Sorry to hear about that. So ruling, if the court has granted summary judgment, that's the danger, is that it's a legit judgment. It's just like you went to trial and you lost. So what they will do is they will look to see if they can figure out where you're employed. If they already have that information, or sometimes they're able to pull your credit report, and you can see if you pull your credit report, you'll see often it has old employers or even a current employer, and they can garnish bank accounts, and they can garnish wages with that. I usually recommend looking at options, possibly, you have appeal rights. That's an option. It's something really to talk to an attorney about, but you have the option to appeal. You have an option for what's called a motion for new trial, or settlement. And so if it's something where, the judgment was entered a little while ago, you can reach out and try to get that settled and maybe suggest a payment plan or proposal for that kind of thing. So sorry to hear about that, Marcos. But yeah, definitely take action quick, because otherwise you could end up with a wage garnishment. So, all right, let's see. Let me answer this question here, because someone bought one of my templates. You bought the template, the response template. I'm guessing that's the answer template. You filed it with the court, sent a copy to the debt collection attorney, which is exactly what you're supposed to do. Now, what do you do? So it depends on the jurisdiction you're in, or what state you're in. In most states, now what happens, once you file the answer, you're no longer at risk of having a default entered against you. And so now the courts will, or the parties will enter into a kind of a discovery phase of the litigation. Usually in most states, there's some type of what's called an initial disclosure statement. In Arizona, it's due 30 days after you file that with the court, after you file your answer with the court, where the parties have to exchange any exhibits and lists of witnesses. The parties may ask for additional documents. You can request information and documents from them. So that's really the next phase. At any time, though, now you can get this motion for summary judgment, which we're talking about. And so it's important, anytime you receive something, you need to, whether you're talking to an attorney or you're researching it on your own, you need to see what you need to do in response to it. Don't ever get something and just ignore it, or just say, I'll figure that out later. Every single thing that comes through the mail is important, and usually is very time sensitive. So make sure you check that. So, all right, let's see here. Laura, another one of the big supporters of the channel. In California, but wondering about the timeline between setting a trial date and actual trial happening, specifically when a pretrial conference might happen. Well, like you said, you're in California, so I don't know exactly how they do it. I can tell you in Arizona, it varies on the type of court that we're in. In Arizona, we have this two-tiered system where they have the justice courts that deal with anything under 10 grand, and then anything over $10,000 is dealt with our superior court system. In justice court, the pretrial conference is usually about 60 days after the answer is filed, and a trial will be set usually within 4 to 6 months after that. Our superior court, or that deals with the larger cases, it's a whole other big mess. I mean, it's one of these things where on average, it takes at least a year to get a trial date. The wheels of justice move very slowly in civil cases, and so I would anticipate California is going to be something similar. And in a lot of jurisdictions, particularly with the larger cases, they're seeing things even backed up more, because during COVID, a lot of the trials were postponed. There were a lot of judges have a criminal docket, and the criminal docket, there's some constitutional issues as far as, speedy trial. They have to get a trial first before the civil cases. And so it's just been delay upon delay upon delay. So I would guess, it's going to be at least 60 to 90 days. That would be fast. And on the larger side, I just had a case. We had a case last October set for a jury trial this October, and it finally settled. But it was a year in advance kind of thing. All right, let's see this one. Do I have money that I received to my trustee? Do I have money that I received to my trustee in a Chapter 13? I need to, okay. Let's see if we can figure this one out. Report any money I get. Okay, there's the question. The question is, do you have to report any money that you receive to your bankruptcy trustee? So in a Chapter 13 case, the idea behind a Chapter 13 is that you are going to contribute your disposable income to your creditors for a 3 to 5 year period, depending on how long your plan is. And so all of your disposable income has to go to your case. And so if the question is like, what if your job changes, or you get a raise, or you get a bonus, or on the other end, if you lose your job, that information does need to be reported to the trustee. It's usually, in most scenarios, at least here in Arizona, it's not like a month-to-month thing. If your paycheck's $50 higher one month and not the other, it's usually got to be a pretty substantial and regular change, whether it's an increase or a decrease. Some trustees will look at your tax returns each year, and they can make you adjust your plan payment either up or down, depending on what's happening in your life. So it does have to be reported, but it's usually not. In most jurisdictions, I've never seen it where they're asking for specifically every month, what was your paycheck kind of thing, unless you're self-employed. Self-employed people in Arizona, they have to submit a report, kind of a profit and loss statement that shows exactly what the income and the monthly expenses were. All right, let's see what Skillet 30 has. If a collection account is sold to another collection company after it was removed, doesn't the new collection company have to send a new dunning letter? Yes. So this, you're asking a question under the Fair Debt Collection Practices Act. And if the question is, I guess more is if ownership changes hands, do they have to send that? Because, and maybe you can give me some more background. Okay, you did give me more background. I just have to look down here before it's put back on the credit report. I'm going to say I don't know that off the top of my head. You stumped me. That doesn't happen too often, Skillet 30. I would have to research that to be able to tell you for sure if, and there may be someone in the chat that does know that's had that specific issue. I don't do a whole lot of Fair Credit Reporting Act type litigation, but that sounds like that would be kind of a combination of the Fair Debt Collection Practices Act and the Fair Credit Reporting Act. So I am sorry you stumped me for once there. That's something I'd have to come back to. All right, let's see. Oh, Skillet 30. See, this is what's great about having it live. I can get some additional info. If it did change hands, if there's a new owner, yes, they should have to send you a new letter saying that they are now the owners of it and that they are going to, and usually they give you a 30-day period to ask them for you to provide information and verification of the debt. So yes, that would be an issue there. All right, let's see. John Johnson says, I'm sued by Portfolio Recovery Associates or LVNV and get a mutual dismissal. Will I receive a 1099-C? This is a great question. This is something that I actually even include in my representation agreements, that if you get sued by a debt collector and you settle the debt, so you're paying something less than it's owed, anything over roughly $600 where there's an amount forgiven. So for instance, let's say that you are sued for $10,000 and you agree to settle it for $3,000. So they forgave $7,000. Then the debt collector, the creditor, is required to issue you a 1099-C for the amount that they forgave. So the $7,000, and they usually send them in January of every year. And you have to count that as income on your taxes. So it's as if you receive $7,000 in addition. And so if you made $50,000 one year and you got a 1099-C for $7,000, then it really looks like you made $57,000, and then you pay taxes on that amount, which is a bummer, this whole 1099-C issue. This is an issue I often tell people, if you're expecting a 1099-C, particularly if it's a large one, if you had a settlement and it, a big one, like say you had a $50,000 case and settled for 20, definitely use an accountant, CPA type person to help you with your taxes, because there are ways around it. Usually, from what I've seen, if you are technically insolvent, if your debts outweigh your assets, there may not be any 1099 liability, but it's for sure something to bring up to an accountant and make sure that they're aware, and have them research that for you if they don't know it, so that you can have that dealt with. Because that can become an issue. Now, your question specifically is if there's a mutual dismissal. There are ways where you can have them put in an agreement that it's contested, that it was a contested dismissal, and that you're not admitting any type of liability. In those types of situations, that there's language in there to that effect, often they will not issue the 1099-C. Because technically nothing's been forgiven. It's just a dispute that's been resolved. And the way that it was resolved is through a mutual dismissal. So, all right, let's see here. Let me go back to E. Cortez. Small town in Western North Carolina, can't find a local consumer attorney. I don't know if you've looked. I would recommend going to the consumeradvocates.org, which is the National Association of Consumer Advocates. It's a website, and they have a bunch of attorney listings broken down by different parts of the country. that may be a place to start to look to find someone who could help you, or you could contact the state bar in North Carolina and see if they have any attorneys who do any type of consumer defense type stuff. So, all right. Got to get Homer Simpson on here. All right. Homer says, avoided getting served by Cash LLC in a lawsuit for 8 months. Cash LLC is a junk debt buyer. They finally gave up and the case was dismissed without prejudice. What are the chances of them refiling? In a lot of situations when debt buyers, when a case gets dismissed, it's kind of hit and miss whether they refile it. There's a couple things they have to look at. One is they have to look at if the statute of limitations is now run. Because if a case gets dismissed, the statute of limitations is the time period from when the account goes into default until, then there's a period of time up until when they can file a lawsuit. And if too much time goes by, like for example, in Arizona, it's a 6-year statute of limitations on a credit card. So from the day that the credit card you stop paying on it, they have 6 years to file suit. If they file the suit at 5.5 years, and then like in your situation, then 8 months goes by and then it gets dismissed. Now, if they refile the suit, it's going to be outside the statute of limitations. So they're going to look at that to determine, because they don't want to do that. I mean, truthfully, they don't, because it's an FDCPA violation and they could end up having to write you a check over something like that. So it's hard for me to guess. One kind of unique thing about Cash LLC, Cash is they're a junk debt buyer, but they went through bankruptcy like 3 years ago. They went into Chapter 11 bankruptcy, and then all their accounts were sold to a company called Resurgent Capital. So it's kind of interesting to me, and I brought this up forever early on, and I got a lot of judges with eyes glazed over, just as far as, to me, there was always a question of whether they could even pursue this. Because who actually owns the accounts? Because what happened is they filed Chapter 11, and then the rights to receive payment were sold by a bankruptcy trustee to these other entities who then were trying to collect on them, but they're still trying to collect in Cash LLC's name, and it was just a complicated mess. And so because of that, I have seen Cash cases kind of slip through the cracks a little bit as far as them not pushing them. So I think you might be in a decent situation to maybe have that one go away, but watch for it, obviously, to make sure that it's, if it does happen to reappear. All right, let's see this one from Mercedes. I have a lawsuit. They want to settle, but I don't have money to settle. What should I do? This is the age-old problem right here. They want money, but it's rare that it's a situation where someone wants you to pay or wants to pay, and then there's a fight over it anyway. The question, so what I tend to do, if there's a lawsuit, first of all, if you can't settle now, is to look into buying some time. So you need to respond to the lawsuit. If you file an answer to the lawsuit, again, you're ahead of the game. 95% of people don't respond to the lawsuit. And if you respond to it, kind of like the question that I answered with Laura, it takes forever to get a trial date. And so you're going to buy yourself at least several months, and maybe in some cases a year, and maybe a situation will change. Maybe you'll get a tax refund. These stimulus checks are coming in. A lot of people are using those to settle out claims. Those types of things you can deal with to try to get some additional funds. Another option, if a lawsuit's been filed, is sometimes you can work a settlement where you are trying to do what's called a stipulated judgment, where you're making payments over time, where you sign an agreement with them that you're going to make these payments, but the agreement is a judgment. And sometimes we call them pocket judgments, where they put it in their pocket, and then as long as you're making the payments, whatever it is, then it's great. If you stop making payments, they're permitted to go and file that judgment with the court. That's one way. Sometimes you can get some pretty low payments with no interest, get the debt dealt with, and not without having to come up with a big lump sum of money. So, all righty. Papa Smurth, great. We got people from New York. Appreciate you checking in here. So, all right. I think that is about it for questions for today. I thought I would end with something here. One of the other comments I got over at the over the channel here. I get trolls every now and again, and if you follow the channel and see my comments, sometimes I'm kind of snarky. I respond back to them. This person said, "It's hilarious how bankruptcy is just accepted now. It's a perfect example of how society has just lost all dignity. It's simply laziness." Wow. They're going to throw that out there on the channel. And I can't just let stuff like that go by. Let me tell you kind of my approach and thoughts to comments like this. When it comes to debt issues, bankruptcy, of course, I mean, the bad decisions lead to a lot of these issues. I can tell you this, though. I always make a distinction. There's a distinction in my mind between if someone was to say, okay, I'm going to incur a bunch of debt, there's zero chance I'm ever going to pay for it, and then I'm going to file bankruptcy, and that's going to be sweet. In almost 20 years of doing this, I've seen that happen, I think, 0 times. Maybe once I saw somebody kind of playing the system. But I mean, I've met with tens of thousands of families. I don't see that happening. What I see is that people are honestly, they're incurring debts, they're going along, they're able to pay them for a number of years, and then something happens in their life and it's so that they can't do it. I have filed bankruptcy for people who have made 10 times the amount of money I will ever make in my life. And so I always say when it comes to particularly serious debt problems where bankruptcy is needed, there, but for the grace of God go I kind of thing, that it's a situation where there's a medical thing, job loss. 2008, we saw the economy fell apart. I met with contractors that were, huge contractors in the Phoenix area that all of a sudden everything was shut off in 2005. The banks pulled their lines. And so things happen. So for someone to throw this out there, they don't agree with it. And I think it's just a cheap shot. And like I said, hopefully, this person who wrote this doesn't end up in a situation where they're needing it. There are definitely things we can do to be financially responsible. And I know that most people are trying to do that day in and day out. And it tends to be just the life happens kind of thing. So, all right. Why I was on my soapbox there's a few more questions. I'll do a few more. All right, Tiffany, what happens to a lawyer's fee and court costs from a judgment when you file Chapter 7 bankruptcy? Goes away. It's as if it never happened. The court costs, judgments, they go away completely. The one thing you have to be careful of is sometimes, and in some states, and in Arizona, starting in January of 2022, judgments will act as liens against real estate that you own. There is a process to remove liens from particularly homestead property, like if it's your home that you live in. But in general, they just go away. But if they happen to attach under some law in your state, there are ways to do that. You need to talk to your bankruptcy attorney, but they generally go away. All right, let's see this. We'll have this one. John, you'll be our last one. Planning on filing Chapter 7 on 4 credit cards. However, I still have a credit card I'm still using, making minimum monthly payments. How will this affect my means test? This is a good question. I get this question a lot. First of all, if you file Chapter 7 bankruptcy, you cannot pick and choose which debts. All debts are included. Even if you have home loans, car loans, everything's got to be disclosed. Unsecured debts like credit cards, medical bills, they're going to be wiped out. Early on in my career, I'd see a credit card that would, if you kept the payments current, they'd keep it out. I don't see it anymore. It's going to be wiped out. The fact that the credit card usage of itself will not affect the means test. But the means test, the only thing they're going to look at, and the means test is how they determine if you're going to qualify to file Chapter 7, is you look at the 6 months prior to the filing of the bankruptcy, not counting the month that you're filing in. So, for example, if you're filing bankruptcy in the month of October, we're going to look at your income from September 30th, and we're going to go back 6 months. And that's how they're going to determine. They're going to look at that and that alone with some of your deductions to determine if you're going to qualify for a Chapter 7. So, all right. We'll see this. Can you please do a sample hearing for us? Example, plaintiff says this is how we should respond. Judge says this is how we respond. If I did that, how would who's going to hire me? I'm just teasing you. I do have a course that goes into detail on how to prepare for trial. I also have a video on how to cross-examine a witness. It's on the YouTube channel. It's one of the free ones. You can take a look at that. That will show you that. Because, I know that here's what we'll end it. A lot of times when you get into court, we get too caught up in, and lawyers do this too, we get too caught up in the formalities of it. And there is some formalities that you have to adhere to. But this is a good thing. I will do a video on this. I will kind of walk you through what that's like and just kind of the flow of how things go. Because a big part of court And one thing I've often told people, if you have a court hearing coming up, one of the best things you can do, particularly if they're in person, a lot of courts are going back to in person, is go look at the court's docket, it's public, and see when they have another trial or another hearing that you're going to be going to by a junk debt buyer. Look it up and then go and sit in the back of the courtroom and watch. They're public, anybody can go in there. It'll alleviate so much of your nerves just to see how your judge handles things. Then you know what to expect. I remember as a brand new lawyer, I went with my partner that I was working for, and we went to court, and I kind of sat there and watched it, and I went away and I said, I can do this. I had built it up so much in my mind that sometimes if you just go in there, you're like, yeah, that's not that bad. So, all righty. That's going to do it for today. I got to run, but I appreciate everybody checking in. Again, you can check out the link there that I pinned it to the very top if you're interested in some of those tutorials. And go ahead and put, if there's comments you want to put over there on the YouTube channel, like I said, I'm trying to pull some of those each week and we'll deal with them. With that being said, we will catch you next Thursday.